crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. Since late 2020, the SEC has started litigating against Ripple. As we enter the third quarter of 2023, anticipation for the court's decision on this protracted dispute only intensifies. The majority of people expect a favorable verdict for XRP before the end of the third quarter of this year. The question on everyone's mind is, when will the Ripple and XRP lawsuit end? Members of the internet crypto community had a brief conversation about this on Twitter. Let's analyze the many factors that have contributed to the XRP lawsuit's protracted duration. This tweet suggests that both parties have been stalling in order to gain an advantage in the legal battle. The case received a lot of attention, according to one responder, but if it drags on too long, people will lose interest. According to this remark, XRP's value will skyrocket because of its practical applications. So, in their view, XRP investors will see their wealth grow exponentially over time. As a result, the SEC is trying to lengthen the litigation in the hopes of reducing the number of persons who benefit from it. Another comment suggests that the judge in the XRP litigation is waiting for the parties to settle rather than going to trial. At the same time, Ripple is allegedly postponing the litigation in order to bring on additional AUDL, according to the same answer. In the latter scenario, Ripple is able to amass consumers, clients, and users who are willing to purchase XRP at a discount. Mike concludes my remarks in my answer. They also note that they anticipate the XRP case will conclude in the next month or two, bringing us closer to the conclusion of QA 2023. Furthermore, another statement claims the XRP case will not be resolved for another year. However, they don't provide any justification for why they hold this opinion. Instead, another comment suggests why the XRP case may be over in a year. The American judicial system is notoriously sluggish, so it is probable that any holdups are due to that. The XRP and crypto community as a whole is behind Ripple in this protracted legal struggle. The SEC is said to have a paltry 3 chance of victory at best. The recent drop in XRP pricing is consistent with the first explanation. The longer the judgment takes to come down, the more investors lose patience and sell at a discount. Meanwhile, believers are stockpiling XRP, hoping for their time to shine. On July 11th, John Deaton shared details on Judge Annalisa Torres' extraordinarily high rate of compensation for her rulings. Since December, when reply papers were submitted by Ripple and the U.S. SEC, the XRP community has been waiting for Judge Torres' ruling. 7 months have passed, but Ripple isn't Judge Torres' only case. He said that Judge Torres has failed to issue a ruling in the Thor Equities case despite the fact that the reply papers were submitted in December. However, he disclosed that Judge Torres waited 6 months to declare her judgment in the Fitzgerald case and numerous other cases, and 7 months to announce her decision in the Quiller, Ince vs. U.S. case. Since Deaton has put in the same amount of time as her opponent, she thinks she has a good chance of winning this month. David Schwartz, ECTA of Ripple, responded to Deaton that he anticipates a summary judgment verdict by the end of September. Since Judge Torres' ruling has never been delayed for more than 9 months, Deaton says he agrees with Ripple Q David Schwartz. Although Deaton did not look at every instance, he didn't find any that were longer than 9 months, although one was slightly longer than 8 months. The long-running litigation between the United States Securities and Exchange Commission, SEC, and Ripple was partially resolved, sending cryptocurrency markets into a frenzy. However, many investors seem to be overlooking the second part of the CQZ, Ripple issue, which might be expensive for Ripple. Former SEC employee John Reed Stark shared his opinion on the SEC's EVs. Ripple litigation development in a LinkedIn article. Stark comments right up that Ripple's victory, however partial, resides on shaky grounds. But he admits that this is a setback for not just the SEC, but also its chairman, Gary Gensler. The CQV's Ripple judgment is divided into 3 sections. Institutional sales. These are sales made to sophisticated investors and people under a signed contract. The second type of programmatic sales comprises the selling of XRP exchanges, and the court concludes that XRP is not a security. Other sales include XRP sales to insiders, ordinary investors via exchanges, and founders. The XRP coin is not a security in this circumstance. The former SEC official observes that the Ripple decision is troublesome on multiple fronts as a result of this classification. He continues, establish a class of quasi-securities that discriminates and morphs based on the sophistication of the investor who is buying the securities. According to Stark, this is counterintuitive, inconsistent with SEC case law, and unprecedented in this context. On the subject of XRP transforming into security or not dependent on investor intelligence, John Reed Stark observes that this argument seems contrary to sacrosanct and basic investor protection principles. Finally, Stark points out that the judgment indicates that only rich investors are protected by the SEC, while less knowledgeable and ordinary investors are not. In other words, affluent people receive help and recourse, but impoverished people get caveat emptor. This seems unreasonable and undermines the fundamental premise of US securities rules. While there is a genuine risk that the judgment favoring Ripple and XRP supporters will be reversed, it will take some time for it to go through right channels and reach a result. Meanwhile, this decision might be the catalyst for a major bull run. After the historic verdict of the U.S. session on July 13, the U.S. Securities and Exchange Commission, SEC, has replied to the ruling by Judge Torres. The long-awaited summary ruling in Ripple v. SEC had just been issued. The presiding judge, Annalisa Torres, came to the conclusion that XRP did not qualify as a security under specific conditions. The SEC's reaction to Ripple's shared victory. The U.S. SEC went home with a victory, albeit a partial one. Following criticism and mockery from the XRP community, the Commission has made clear its position in light of the court's ruling. The SEC may be examining the matter further in light of the comments published by Fox Business. Paraphrasing some of the reply, nonetheless, the agency concedes that it won since the judge ruled that Ripple offered and sold the tokens as investment contracts in violation of the securities laws in certain circumstances. The court ruled that Ripple's sale of XRP to financial institutions was a violation of securities regulations. They were given permission by Judge Torres to sell the asset to the public. Notably, the court agreed with the Commission that the Howey test applies to the securities investigation of Bitcoin transactions. As shown by the summary ruling, the court also disagreed with Ripple's definition of an investment contract. However, the court's judgment made it obvious that the SEC does not have limitless authority over crypto, which may account for the fervor in the crypto market. In response to Ripple attorney John Deaton's request that exchanges list or relist XRP to indicate support for the verdict, the Kraken and Coinbase markets have already done so. This shows the industry's alignment, with crypto leaders like Binance's CEO congratulating the Ripple camp on the victory. The case that the Commission had against Coinbase, which had sold 13 tokens classified as securities via the exchange rather than on launchpads like ECOS and IOs, is rendered completely moot. CoinDesk contributor Preston Bren, meanwhile, believes that the judgment from July 13 merely guarantees continuing uncertainty for crypto issuers, and that only Congress can rectify the situation. However, now that they have been vindicated that Gensler no longer has exclusive jurisdiction over them, altcoins have flashed green following the news of the ruling, suggesting a buying frenzy that saw XRP naysayers miss out on 70 gains while holders of Solana, Sol, Polygon, Matic, and Cardano, ADA, raked in around 20 profit. In its statement, the SEC discussed Ripple's partial victory and how the court had rejected the defendant's proposed test. The judgment will be reviewed by the agency, which might lead to a trial down